Good morning. My name is Tony Fazzio, and I'm running for the 14th JDC Criminal Magistrate Judge position. It's a new position. First, I'd like to thank the Black Business Owners Association for having us come out, because we do need informed voters, and especially in a position like this, which I don't think people are understanding the importance of. This is a chance for me to tell you who I am, what this new position is going to be, and what my thoughts and how to handle that position. So just to tell you a little bit of myself. I'm a lifelong resident of Calcasieu Parish. I'm a graduate of St. Louis High School. I went to LSU, where I graduated in 2002 in biological sciences, and then I graduated from LSU Law School. After that, I came here locally. I clerked at the 14th JDC for Judges David Ritchie and Judge Clayton Davis. From there, I went up to Baton Rouge for about a year, and I did some civil litigation involving mortgages for major banking institutions. I returned back here, where I was an assistant district attorney at the 14th JDC District Attorney's Office, where I held various positions. Among them, I was the misdemeanor section chief, the juvenile section chief. I assisted with the drug court and DWI court programs, and I left there and I went into private practice, where my practice is mainly focused on criminal defense with the Sanchez Law Firm. First thing I want to talk about is, what is this magistrate position? It's a new elected position. We've had it for a couple years now as a hired position, where some retired judges were holding the position. But now that's elected position, it's kind of grown. That's one question I've been getting a lot as I've been talking to people is, what are you running for? Everybody knows, well, if you're I'm calling them the full judges, they do everything. Well, what is it that you can and you can't do? The simplest answer is, I can only do criminal stuff. The way the statute is written, it's strictly a criminal position. And then there, I kind of subdivide and say, essentially, what he can do is anything but try felony cases or take felony pleas. Felony is anything punishable for over 1 year. So the majority of what the magistrate judge is going to be doing are the misdemeanors, which I'm infinitely familiar with, having been the misdemeanor section chief at the DA's office. I was in charge of the prosecution of all the misdemeanors in essentially Calcasieu Parish that the DA's office handled. So I prosecuted them in the 14th JDC, Lake Charles City Court, and Sulphur City Court. Now, I can't say I was in charge of all of them, because the city prosecutor's office does some, and there's a Sulphur City prosecutor. So I can't say I was in charge of all of them, but I was in charge of the majority of them. And I think it gives me a unique view on what this position needs to be. The other thing that's going to be doing a lot of is your arraignments, which is the first step in any criminal prosecution. It's when you're formally charged. It's where you go in for the first time, you're going to enter a plea of guilty, not guilty, or no contest. So essentially, if you're going to go to the 14th JDC on a criminal charge, you're going to see me. I may not hold the whole case, but at some point you're going to come in front of me. So that's going to be important. Another part of it is you're going to be handling the traffic violations, which again, that's where most people who are going to come in contact with our court system are through a traffic violation. I think we can all admit we've all had them. So that's something we're going to be seeing a lot of. Another part of this, which I think is going to be the very most important part of this, is the setting of bonds. The way it's been talked about from talking to some of the judges is that the magistrate judge will be the criminal duty judge 46 weeks out of the year. So that's the individual who, when they're coming with your arrest warrants to set bonds, that's the person that's going to be setting those bonds. When they're coming to get search warrants, that's the person who's going to be signing those search warrants. They're going to be doing what's called Gwynn's Law hearings. For those of you who aren't familiar with Gwynn's Law is essentially dealing with felony domestic violence in the setting of bonds. Instead of just the judge signing off on a bond, there's a hearing. And so I would also be doing that. Now, the weird part of this is the other stuff, which is the pretrial motions that the felony judges will be having. The magistrate judge can do those. The question is, will they be doing those? That is at the discretion of the individual judges. So one judge may say, hey, we want the magistrate judge to handle those motions. Some may say we don't want them to handle all. Some may pick and choose what they send. So this magistrate judge, number one, is going to be someone who's going to be hardworking, because they're going to be in court all the time. That's one thing I'm going to tell you. I'm here to have court. I'm not here to sit on a bench for half a morning and then leave at noon or something like that. I promise you, we're going to have full days of court, because my job is to assist the full judges in the efficiency of the dockets. They are overburdened. they don't have enough court time. So the goal of this magistrate judge is to take some of that court time that they already have away from them. That gives them more court time to take the more serious things. So it's just kind of this really dynamic thing, and I'm hoping that if I'm elected, I'll be the first person to hold this position, and I'll have some ability to shape what that will be in the future. So kind of some of those things, how I view them. One thing really important to me is access to justice. If you go to court right now, what you'll see is a bunch of people, they'll go to a courtroom, very little is done, things get kicked down the road, continues over and over and over again, and these court days are taking all day. It doesn't need to be like that. So one thing I'm going to tell you, efficiency starts with me. I'm going to be in court at 9 a.m. every morning. Not 9:05, not 9:10, not 9:15, not 11 o'clock. I'm going to be there at 9, and that's when court starts. So the prosecutors, the defense attorneys should know that if I'm elected, well, I better get to court early. If I'm going to talk and try to work stuff out before court starts, well, it's on me to make sure I'm there at 9 so they know I'm going to get there early to work my stuff out. Court starts at 9. If we got to go to 5, we go to 5. We got to go to 6, we got to go to 6. But we're going to make sure everybody's taken care of in an orderly fashion. Part of that is also not taking all day for things that don't need to take all day. Continuances don't take a long time. Pleas sometimes, because I'll be taking some pleas. Those don't need to take a long time. People, if they're coming in, they're accepting responsibility for what they've done. We're there to get them out, get them on their way, hopefully having made this a one-time mistake, and they move on with it. Because what I've seen in my practice is you go to court, especially when I was a prosecutor, I'd see, we get there at 9 o'clock in the morning, court starts 9:15, 9:30, 9:45. We take a break at 10, 10:30. Judge says, I'll be back in 5 minutes. They're not back for 30 minutes. We break for lunch. We come back at 1:30. And these people who have jobs, they're taking their whole day off of work. They don't need to be doing that. If we can get them in and out, that's the way we should be doing these things. Another part of that efficiency issue and that access to justice issue is technology. As we all know, with the coronavirus, kind of like this, we're having to depend on technology to kind of get us through these things. That's something I want to embrace and continue, because hopefully whoever gets this seat will take the bench in January, and hopefully we'll be a lot further along on this process, and it won't be a necessity that we have Zoom and things like that. But I think it's something we should maintain because it's allowing us to be more efficient, allowing us more access to justice. The way I foresee this happening is I'll start court at 9 o'clock in the morning. People will then, ahead of time, be able to opt in to an afternoon session of Zoom, what I'm calling Zoom court. So that way, if you want to come in first thing in the morning, you know you're going to get going, you're going to get moving. If you have a job and you can't get off of work, well, you can tell your boss, hey, look, after lunch, I'm going to need about 15, 20 minutes. You log on to your Zoom, you log on with your attorney. If you have the public defender's there, and we get you moving. That way, you're not taking your whole day off. You're able to get in, get out. Because it's easy to say, you got a private attorney who's coming in. Well, we're pretty good about getting those people out. But we still have the individual litigants who still need to be able to get out. And that includes our law enforcement officers as well, because those guys will come in and days off, and they want to get out. No one wants to be in that courtroom for any longer than they have to, and I want to help them move along. There's also part of that access to justice, though, is access to real and true justice. I was a misdemeanor section chief. We didn't try a lot of misdemeanor cases. It wasn't for lack of trying, it was for lack of time. I talked to some of the misdemeanor ADAs here recently, and they estimate they had less than 10 misdemeanor trials in the last year. That's unacceptable. That's not access to justice. That's not allowing somebody to come to court and plead their case. It's just, we're getting a conviction, and we're moving on. So if you want to go to trial, I want you to go to trial. And you don't have to be afraid that you're going to be penalized for going to trial. That's the other thing. A lot of people are scared. Well, I know if I go and I take my plea, I know it's in front of me. I know it's not going to be serious. But if I go in front of that judge, they're going to penalize me because I took the court's time. And I've heard it said, I wasted the court's time. Trying a case is not a waste. That's what I'm there for. I want to call the balls and strikes, so to say. I don't want to be the judge who just says, so ordered, so ordered, so ordered. I want there to be things for me to try. And access to justice also is for victims too. A lot of times you have victims who have never gotten their say, their day in court. Well, they want their day. They want their say in court. They want to know what's going on, and that's important. And we start that by having time for trials so that everyone knows, okay, we're going to have trials. So we need to be prepared for those, and the defense attorneys especially know that is an avenue that I have that I don't have to be worried about if I'm taking a risk of my client. If I have a case, I need to try that case. So that's important we have that access to everyone. Another thing important is accountability. That's accountability to everybody. Accountability starts with me. What can I say about that? Like I said before, being in court on time is the easiest way to do that. Is I'm accountable to the citizens of Lake Charles, citizens of Calcasieu Parish, that they know I'm going to be in court. I'm not going to be wasting time, wasting their tax dollars by people just sitting there. I'm accountable when I set my bonds. I'm accountable to two sets of people. I'm there to protect the general public by setting bonds that are reasonable, that ensures people who shouldn't be out, people who are a danger to society aren't out. But most people, that's not them. Most people are coming in with one or two non-violent offenses. Those people don't need extremely high bonds that they're sitting in jail when they should be out walking and working. That's important. So I've got to be accountable to everyone. I've got to be accountable to the lawyers, make sure I'm not wasting their time. Accountable to the litigants, that I'm not wasting their time. Accountable to the court staff, that they know, hey, if I get assigned to Judge Fazzio, well, I know I'm going to be in court, and they know that, and they can plan their schedules around that. Accountability goes to the prosecutors. They need to be prepared for their cases. They need to be prepared to give good, reasonable pleas. They need to provide discovery in a well-organized, well-thought-out, timely manner. They need to make their offers fair on the front end, not drag things out to try to increase a plea or something like that. Whenever they are in front of me, if they're trying a case, they're trying a motion, that they don't start on third base. They start at home plate just like everybody else. They're accountable to prove their case beyond a reasonable doubt. I think that word, or those words, are ignored or misrepresented a lot of times. It doesn't seem like they're held to that standard. That's a high standard. They need to be held to that. Same thing for defense attorneys. They need to be prepared for court. We don't need unnecessary continuances. That clogs up the court's calendar. Look, we're all busy. Look, first fixings, that first time you go into court, not everybody's ready, and that's understandable. You got to get your discovery and you got to be prepared. But your second, your third, your fourth, well, a lot of times that's just a defense attorney not having talked to a prosecutor, not talked to their client, not being prepared. Well, at that point, they need to be accountable to their client, accountable to the court, saying, okay, well, why are we continuing this? Why aren't we trying this? Why aren't we ready to go today? Accountability obviously goes to the defendants. They've got to be accountable for their actions. If they are guilty, they need to be held for what they have done. But that also needs to be with a measure of mercy when it's appropriate and punishment when it's appropriate. Not everybody fits in the same mold, and I think sometimes the judges lose sight of that. I think sometimes the prosecutors lose sight of that. Sometimes even defense attorneys lose sight of that. We need them to be accountable for what they did, not for what they might do or what we think they should have done, but for what they did. I do kind of want to mention bonding, because I think that is the one part of this job that I think people aren't focusing on, but it's probably the most important part of this job, is a bond. Someone is arrested. They're brought to the jail, and they've got to bond out in order to get out. That means they're going to have to pay some money so that they can get out of jail. Well, I think one thing we need is consistent bonds. Right now, we have a bunch of different judges, and their bonds kind of fluctuate. Well, I'm going to tell you that my bonds aren't. If one person is charged with one crime, one person is charged with the same crime, well, you know what? They're going to have a consistent bond. That's something you need to be able to kind of depend upon. That, you know, if you come in front of Judge Tony, he's the one signing your bond, you have a pretty decent idea of what you're looking at. Part of that is looking at, number one, what crime are they charged with? Two, how many times have they committed any crime, or that particular crime, or things like that? What I see, and it's one thing I didn't like as a prosecutor, I like even less as a defense attorney, you have people who have nonviolent felony crime. And I'm not going to be able to try that case. I'm not going to be able to sentence that case. But I will be setting a bond on that case. Well, realistically, in the majority of those cases, what's going to happen? If the person is able to bond out, they keep walking, they keep working, their life doesn't change that much, they're going to end up with a probated sentence if they plea or if they're so they're never going to see an inside of a jail cell for very much time if they have the money to get out. Well, but that same person, let's say they don't have the money to get out. Their bond is too high. Well, what's going to happen? Well, they're going to sit in jail 6 months, 7, 8 months by the time they've got their arraignment. Discovery sent out. They get their first court date. And what they're going to do is they're going to come in and they're going to plea to whatever that prosecutor wants them to plea to and get that magic word, credit for time served. Credit for time served. I get out of jail. I want out of jail. I'm going to plea to whatever it is you want. What's the difference between those two people? Money. So we have one person who they spent a couple hours in jail. Their life really wasn't changed by this experience. We have this other person who, let's be realistic, is going to be lower on the socioeconomic scale. Money's already tight. Well, now they've lost their job. They've lost their house. I've seen where they've lost their family for the same crime that someone with a little bit more money was able to kind of take in stride. That's not right. That's not right, and we need to understand that. Now, look, I'm not saying that everybody should just get a low bond and that be the end of it. I'm not saying that. There are people who need high bonds, people who need to stay in jail, people who need to show up to court. That was one of my pet peeves as a prosecutor, was people who didn't show up to court. Bench warrants. Part of that efficient process is you got to come to court in order for this thing to move along. Well, you have people who have 2 and 3 and 4 bench warrants. They're not showing up to court. Well, those people, well, you don't show up to court. Well, we're going to help you show up to court. Maybe that means your bond's revoked and your next bond's going to be a little bit higher. Well, because if a $5,000 bond didn't make sure you got to court, well, maybe a $10,000 bond will. Or you commit your crimes, well, but maybe we might need to have a higher bond to make sure you understand what you're doing. But it's important to understand at all times, these are individuals who have not been convicted of any crime. To be arrested, all you need is probable cause. That's not beyond a reasonable doubt. So people should not be held in jail because they're too poor based upon probable cause. It needs to be at a level, a reasonable but effective bond to make sure, because bonding is there to make sure they show up to court. Now, if we have people with, we're talking about nonviolent first, second offenses. Now we have people with laundry lists of crimes or very serious crimes. That's a different story. But that individual is going to be the person who's setting your bonds. And that needs to be somebody who is reasonable. Someone who they're going to be able to have access to. Not just law enforcement, the bond signed, but someone that, mom, dad can call in and say, hey, look, little Sally, little Johnny's been arrested. I need a bond set. So they can have access to the judge's staff to get those bonds set in a timely manner. So we can hopefully get them out, that's my term, out working and walking. We need people, that's where they need to be, working, walking out. Now, the one thing I'm going to tell everybody I don't know the answer to, I've talked to some of the candidates and and some of the judges, and they've kind of given me an idea, is what's going to happen to bonds after the magistrate sets them. Some of the judges have indicated they're going to allow them to keep hold of that. So if there's a motion for bond reduction or something like that, the magistrate will be able to the person's going to take care of that. Some of the other judges have indicated that once the magistrate sets the bond, it's their bond to do with what they will. As the magistrate judge, I have no control over that. I have no control over once that bond is, because it becomes a pretrial motion. That is the judge's precedent to decide who goes where, who does what. So I have no control over that. Part of that is Gwynn's Law hearings. We don't have hearings. We get a piece of paper and the judge looks at it and he sets a bond. These need to be legitimate hearings. People have something to say. They need to have an opportunity to say it because they're hearings. They're important. Again, these are people who have been accused, only accused at this point, of domestic violence against a dating partner or spouse. We've got to admit, that's a serious crime we have. That's a serious issue we have. But they still need their day in court for those bonds. Another thing I'm kind of passionate about is the alternative courts, DWI court, drug court. I was a prosecutor in that. One thing I'm very happy that that the legislature had in their packet was that the magistrate judge is going to be able to assist with those. I think those are fantastic programs. They have very good success rates, and I want to be a part of that, because you need judges who are willing to go and do that so the programs can keep going, because they are very worthwhile programs. And my intention is to participate in those programs to the extent my docket will allow, because at the end of the day, my first thing is efficiency, getting judges time to do the more important things. So I'll be doing those, what I would call less important things. They're still important, but they're not trying those felony cases. It gives them, I have no control over any civil dockets, right? I'm just a criminal. But hopefully I've talked to some of the civil attorneys, and their hope is that this is going to open up those judges to have more time on their civil dockets. That's kind of all I have. I'll open up to questions if y'all have any. Yes, sir.
I do have a question, and this is from someone who's watching online. The question was, do you have thoughts or impressions? You talked about technology impacting Zoom court. What is your opinion on having court on the weekend?
I personally have no problem with that. I'm a single guy. I'm built 24/7. I think the problem you're going to have a court on the weekend is going to be the judicial administrator, the sheriff, getting the other judges on board. Personally, I am not opposed to something like that. It's something that we've seen before. I'd be 100% for it, but we have to have all participants in the room to do that.
Thank you.
Attorney Fazzio, again, thank you for being here on the day to address the Lake Charles Black business owners. My question is, I heard earlier that there were a backup on a docket of as much as 700 cases. It's been reduced as such. How do we get to this point? I mean, and I followed up by saying this. I believe the judicial system, for those who don't have, puts a strain on the entire community. Because if somebody gets picked up for a shoplifting or something that may fall before you, they may not have the $500 or the $1,000. And they may not be able, it puts a strain on their families. I've seen grandmothers literally putting bonds up on their homes to get their loved ones out. It doesn't cost a lot. I mean, for $5,000 and $10,000. So how do we get to this point? How do we make it better?
Well, I would say to kind of answer to your question two parts. One, that's what OR bonds, recognizant bonds. That's part of that being available, accessible. One of the things you can do when setting a bond is ability to pay. So if someone doesn't have an ability to pay, even if everything else is going, that's still something you take into account. So that's something, if, like I said, I want to be accessible to people. If I find out that, hey, somebody is picked up for shoplifting, I've set a $5,000 bond. Well, if I get a phone call say, hey, look, this person has no history, but they just can't afford that, well, that's not somebody I want sitting in jail. Well, then I can adjust the bond. And I can say, well, then we're going to lower it. We're going to say what's called an OR bond, which is a recognizance bond, a personal signature bond, where they just essentially get out on a little bit of money in their signature. As to the backlog, I think number one is opening things up to trials, because a lot of times you're holding out for a better deal. And you say, look, I can't get my better deal. Let's try this. Also, it's going to be putting pressure on the prosecutors and the defense attorneys to know you might get your one, your two continuances, but at that point, either we're trying this case or something's happening here. We have a problem where you've seen cases that are behind because they've had 3 and 4 and 5 continuances. Also, problem with people showing up to court. That's what the bench warrant issue is. That was my pet peeve, is if you're not showing up to court, that causes that backlog. So then, well, if you have 2 and 3 bench warrants, we have ways of making sure you come to court. So part of it's making sure everybody works together for the efficient movement of cases.
Ms. Fazzio, Carl Ambrose. I just wanted to ask you, even with everything that's been said here, what effect does the district attorney's office and the clerk's office have on of court?
Well, the DA's office runs the docket essentially. It is their docket. They set the court dates. They set what's on the docket. So as the judge, I can't say, well, I'm going to pick on Mr. Hawkins. Well, Mr. Hawkins' case isn't on my docket today, but I'm putting it on my docket. I have no control of that. The judge only has control of what's put in front of him. So the way we do that is to put pressure on them to say, hey, we know 3rd fix and 4th fix, and well, we're not continuing these cases anymore. We need to make things happen. But because they're in charge of what cases are called, what offers are made, they have a lot of control. Prosecutors have what are called prosecutorial discretion. The way I explain it to my clients is you could get picked up for a shoplifting. Well, they can charge you with jaywalking. They can charge you with first-degree murder. They get to pick whatever it is they want to charge you with. They can say, I ain't charging you with nothing. I'm dropping it. They have that discretion. So a lot with they control a lot of that. And as the judge, I can call the balls and strikes that are in front of me, but I can let the prosecutors know, hey, this is what we do. And I can meet with whomever the new DA is, because we're going to have a new DA, and say, hey, look, this is how I want things to go. I can meet with the misdemeanor section and say, hey, if I'm elected, this is how we're going to do these things. And we're going to move these cases along. We're not going to drag things out. And that's kind of how I can handle it. But that's where they control. The clerk's office is just staffing. They control the staff. If they don't have a staff there, I can't have court. All right, thank y'all very much.